We are delighted to welcome everyone joining in person as well as those who are online. Today's discussion is about the upcoming Supreme Court's case on trade policy, which is going to be on November 5th. And the Supreme Court is going to review the President Trump's tariff under International Emergency Economic Powers Act, or IEPA. And this review is going to have far-reaching implications on not just for the U.S. trade policy, but also for the balance of power between Congress and the executive branch. So in terms of format, we are going to have 40-minute conversation and then open up to the audience questions. And so we are supposed to have a translator, but he's being a little late, so he might be joining us in the middle of conversation, so please understand that. As Gigi mentioned, this is going to be recorded and it's going to be available on KaiPak's YouTube channel, which you can find on our website. So with that, Jesse, thank you so much for joining us this morning. And to begin, let me find your mic. So to begin, what's really happening here, right? So could you explain why this case reached the Supreme Court and the key legal steps along the way?
Sure, yeah. Let me start with a caveat that I'm an international trade lawyer. I'm really a sort of a WTO expert. I've been back in the United States now for 6 years, and I'm trying to understand, how the U.S. Legal system is working. So I'm learning as I go, like you guys are. And I'm not involved in these cases in any way. So I'm not a practitioner. There are probably people out there who are writing the briefs who could tell you a lot more about these cases, although if they're involved, they might have a particular view, which might not be objective. The advantage for me is I'm really looking at this from the outside. The stuff is pretty complicated, and so I hope you don't mind, but I've made some notes for myself, especially for this first discussion. So this is IEPA, which is sort of hard to even pronounce or remember what the acronym stands for, the International Economic Emergency Powers Act, right? So this is a piece of legislation that allows the president to respond to certain types of emergencies, and specifically a national emergency where there is an unusual or extraordinary threat. The source of that threat is outside the United States, and that threat is to national security, foreign policy, or economy. So this is an emergency legislation that gives the president power to act in certain types of emergency situations that relate to our international relations, either economic or political with other countries. So what does this act allow the president to do? It allows the president to do, there's a long laundry list of things the president can do. One of the things in that long list is to regulate importation, right? And so this case really involves, to a very substantial extent, has related to what it means to regulate importation and whether regulated importation includes an authorization for the president to impose tariffs. Now, of course, this is in the background. Obviously, you know what the background is. The president has been using IEPA very, very broadly, basically to impose duties on the world, right? And so underlying all of this, is a set of questions about whether IEPA was intended to sort of, deal with very concrete sort of focused emergency problems, or whether it was intended to be used in this very broad way to sort of redefine our trading relationship really with all of our partners. One more thing to say, and that is that there has to be some kind of a connection between the identification of this threat and the measures that are taken. So the actions have to be actions to deal with the emergency, and I quote here, may not be exercised for any other purpose. Okay, so we have all these IEPA measures being imposed and the president negotiating all these arrangements with different people. Then we had a series of court cases, as you tend to have whenever something controversial happens in the United States. And the first stage of review in the US, if it's a trade matter, is the Court of International Trade. Right? We have a sort of a multi-stage review. We have a Court of International Trade, we have a Court of Appeals for the Federal Circuit, and then we have the Supreme Court. I should say, incidentally, there were also some IEPA challenges taking place outside of this structure, in district courts and things in other places, and probably really didn't belong there. And I think we'll see that, that really the focus of this activity is all going to be this sort of this CIT, Court of Appeals for the Federal Circuit, Supreme Court axis. So that's really where the action is taking place. So there are a few other cases out there, but I'm really going to focus on this. So the Court of International Trade is faced with, a broad-based challenge to whether IEPA can be used to support all of these tariffs that are being imposed around the world. And they take a fairly narrow approach to resolving the. They say no, by the way. The first thing they say is no, that the president has gone beyond the powers that are delegated to him by Congress, beyond his statutory powers in imposing the tariffs that he's imposed. They choose a very narrow basis for that. Let me say, what are the two types of tariffs that are at stake in these cases? They are first so-called fentanyl tariffs, right? So early on, the president says, well, we have an emergency, we have all this fentanyl, which is a highly powerful opioid, right? We have a serious addiction problem. So we want to deal with this fentanyl problem, and he invokes IEPA and imposes duties on Canada, Mexico, and China, right? China, because China is presumably the principal source for the fentanyl. Mexico and Canada, because apparently fentanyl is supposed to be coming across the borders from these places. So the Canadians will certainly say very little fentanyl is coming to the United States from Canada. They have their own serious addiction problem with fentanyl. So there could be a debate about that. But those are the measures that are at issue here. And then second, but perhaps more important, the reciprocal tariffs, which are what Korea is also confronting, which are sort of global rather than targeted at just a couple of countries. So the court is looking at these two types of measures, and it issues quite a restrictive ruling. It basically says, the first set of measures, the fentanyl tariffs, okay, that is, they don't debate that that's an emergency that qualifies under IEPA, but they say that these broad-based tariffs on imports from all, on all kinds of imports are not properly tailored to suit the problem. They don't deal with the problem which has been identified. In other words, sure, fine, this is an IEPA emergency, but the measures are not appropriate and proportional to the problem. They don't really address the problem, right? So that's what they say with respect to the fentanyl tariffs. And with respect to the reciprocal tariffs, what they say is that basically the president is trying to deal with a balance of payments problem. And there's another statute out there that is specifically designed to address difficulties with respect to balance of payments. Section 122 of some trade or another. Anyway, Section 122 is specifically designed to deal with balance of payments problems, and it has a series of restrictions we'll talk about, when and how you deal with those problems, right? So quite narrowly tailored, no rulings about whether IEPA allows you to impose tariffs, no rulings about that, these aren't proper emergencies or anything like that, but really sort of focused on the particular instances. So that's the Court of International Trade. Then this gets immediately appealed to the Court of Appeals for the Federal Circuit. The Court of Appeals for the Federal Circuit recognizes this is very important. So they decide to take this issue up en banc, with a lawyer's level act. En banc is basically, the Court of Appeals has 12 judges. And instead of having a small panel of judges decide the case, they decide this is so important, the entire court is going to consider the case. So there are 11 judges involved in the decision in the Court of Appeals for the Federal Circuit. I think the 12 for some reason was not available. So what's really interesting about the Court of Appeals for the Federal Circuit decision is that they really sort of tackle the whole issue package very differently. So the outcome of the Court of Appeals for the Federal Circuit is the same as in the CIT. They also find that these measures are outside the scope. They're not authorized by IEPA. The president doesn't have the power to do what he did. And this is a decision with a majority decision by 7 judges, a concurring decision, which means they agree, but they have some additional explanations they want to provide. In fact, some different legal reasoning for those 7 judges, and then 4 judges dissent. So you actually have 3 separate decisions here, right? Which is going to be very important when we get up to the Supreme Court, because there are alternative views on how all this works. And so the majority decision is an interesting one. It's when you start reading it, you think they're going to say that IEPA doesn't authorize the use of tariffs. When you're reading the first, sort of 10 or 15 pages, you're thinking no tariffs under IEPA, right? They start out by explaining that IEPA makes no explicit reference to tariffs. When the president is delegated tariff authority, he seems, the statutes tend to provide very precisely for that authority. In this case, they don't. Here, they only authorize regulation of importation. Regulation is different from taxation. And you're thinking, well, they're going to find that, the president can't impose tariffs under IEPA. And they touch on a series of sort of very important legal doctrines that are affecting all kinds of cases in the United States, like the major questions doctrine, which basically says, to put it simply, that you're not going to sort of imply a delegation of power from Congress to the president when the implications are huge, right? It's a major question. You need, sort of pretty clear and explicit authorization for the president to act. And then we have another set of issues which are about delegation, and that comes to the fact that the taxing powers under the Constitution reside with the Congress, the foreign affairs powers reside with the president. So we're going to see this is going to be a continual theme. Is this about taxation, which is congressional power? This is about foreign affairs, in which case it's presidential power. But you read this case and you're thinking for a long time that, as you read the decision, that, they're going to say no tariffs under IEPA, because, all these constitutional principles, et cetera. But eventually you get on to the sort of the final section and it becomes clear that they're not going to go that far. And instead what they end up saying is, well, we're not saying that tariffs can never be imposed under IEPA, but we're saying that in this particular case, we're going to interpret the statute sort of in light of these, delegation issues. And we're going to find that the extent of the power that the government is asserting it has to impose duties, sort of unlimited in terms of to whom they apply to, no limitations, temporal limitations on how long they can stay in place, covering all products, that just seems to be completely unbridled. And so ultimately the majority decision says you can, well, it doesn't actually say you can impose tariffs on IEPA exactly, but it says that in any event, if you are imposing tariffs, you can't impose tariffs as broadly as this, right? So that's the majority decision, which means the president could still impose tariffs under IEPA, but he can't use them to impose tariffs, permanent tariffs at any level on every country in the world. It's basically their conclusion. Then we have a concurring opinion, which is 4 of those 7 judges who want to go further. And those 4 say, actually, no tariffs at all, right? They focus on the sort of constitutional question. Well, first they start with the text, regulation of imports. If they wanted to say tariffs on imports, they could have said so. They have a list of the legislation lists like 15 or 20 types of actions the president can take. If they wanted to say tariffs, they would have said tariffs. But in addition, their conclusion, in addition, they're very focused on the fact that the taxing power is a presidential power, is a congressional power. And there's a lot of historical discussion about how when the Constitution was written, basically tariffs were the principal source of revenue. So tariffs are really not about foreign policy or trade. They're really about the ability to raise funds, and that's really congressional. So we're not going to easily assume that Congress has delegated that power to the president under this statute. So you have sort of the compromise position, sort of the softer position. Yes, maybe tariffs, but not this broad, this unlimited, which is the majority decision. You have this sort of more focused decision, this narrower decision, no tariffs at all under IEPA. You have to use some other tool, and then you have a dissent. The 4 judges and a dissent. And the 4 judges is very interesting to read because they start out, you start out by thinking did they read the Federal Circuit decision because they seem to be addressing the Court of International Trade decision first. But they start out by emphasizing that nobody has questioned that there is an unusual and extraordinary threat here. So the basic underlying legal standard, legal question, the thing that triggers your ability to use IEPA, they say, look, or at least neither the CIT nor the Federal Circuit has questioned that, right? So they say, we do think there is this unusual, extraordinary threat. So IEPA is properly invoked, okay? So IEPA is properly invoked. Okay, so the question is, can you use tariffs? Can the president use tariffs under IEPA? And they say, you know, they go to the ordinary meeting, they will regulate, they go to the dictionary, regulate includes control, and then they find case law that says, well, you can control imports through tariffs. And they say, hey, if the president can ban importation, surely he can impose tariffs too. And there's some discussion about an important case that was not under IEPA, but was under the predecessor to IEPA, which was Yoshida, where the predecessor, the Court of Appeals for Federal Circuit, in fact, allowed certain import surcharges, you know, back in the 70s when the United States came up with the gold standard. So there's some jurisprudence that suggests that under the predecessor statute would have the same legislation that was okay. So, and then what I think is really important to see is then how do they deal with these sort of broader questions about the relationship between Congress and the president and taxing power versus foreign affairs power. And they have a very different take than this, you know, tariffs are all about taxes. They emphasize the importance, the primacy of the executive in foreign affairs, the great deference that courts have always given to the president when he's making foreign affairs type decisions. And they said, even if, so taking all that into account, the important role of the president in foreign affairs, taking into account that very important constitutional role, we're going to apply perhaps, and Kavanaugh specifically talks about this, apply the major question doctrine rather differently in a case where the authorization is an authorization that relates to the president's foreign affairs power, right? So you have this strong line of deference to the president because this is a foreign affairs type of activity and not a tax activity. Okay, so this is the decision, and both sides immediately agree that they want this to go to the Supreme Court. There's the request for writ of certiorari. The Supreme Court gets to pick and choose what cases it wants to decide. It chooses ones that they are important as a matter of precedence, et cetera, et cetera. They immediately took this one up. First set of briefs, the writ has been filed, the response by the respondents has been filed, and the Supreme Court is scheduled for November. So it's all set up now to see these three very different views about exactly what the president can do.
So that was excellent overview of what's going on and how that led up to the Supreme Court on November 5th. So, I mean, you've touched on broader issues here, so we're going to try to unpack, step by step. So you mentioned about three different views on the decision that will come, right? So depending on how the Supreme Court rules, will the U.S. president have more or less power in terms of imposing tariff? Like, how does that affect allies like Korea, and how will allies act dealing with U.S. in terms of trade deals?
Well, I think the answer to that is.
Sorry, Jesse. You have translator now, so he's gonna translate.
그래서 방금 교수님께서 얘기해 주셨듯이 이 대법원, 연방 대법원이 이 판결에 대해서 어떤 판결을 낼지에 대한 세 가지 견해가 있다고 말씀해 주셨는데, 그렇다면은 이 대법원에서 판결이 났을 시에 미국 대통령의 권한, 즉 관세 부과에 대한 그런 권한이 더 약해질지 더 강해질지, 그리고 그때는 우리 동맹국들, 미국의 동맹국들은 어떤 영향을 받을지, 특히 무역 관계에서 어떤 영향을 받을지에 대해서 여쭤보고 싶습니다.
Okay. Well, the answer to that is, quite frankly, I have absolutely no idea because I don't know how the Supreme Court is going to rule, and every expert that you talk to has a different view. My sense from that sort of the non-represented sample of people I've talked to. I know more people who think that the Supreme Court is going to reverse the lower courts and uphold the president's behavior than think that they're going to strike down the president's behavior. But that's a random straw poll of people that I happen to know, so that that doesn't really mean a lot. I'm not a Supreme Court observer, I mean, there are people who spend their lives sort of watching what every Supreme Court justice is doing. They're sort of like Kremlin watchers back in the Cold War, with someone on the podium, during the parade or Red Square. So I'm not one of those experts, but none of those people agree either, right? So one question is, how are they going to rule? Are they going to allow the president to do what he has done, or are they going to strike it down? But the next question is, on what grounds? right? Because, what we have, in fact, is we have a CITs, rather narrow sort of, rulings. We have 3 different types of possible rulings being proposed by the Court of Appeals for the Federal Circuit, depending upon which of the 3 decisions you take. So it's not only yes or no, it is on what grounds. How broad are those grounds going to be that the court will rule on if they were to strike down the measures? And they could do it in a very narrow way, or they could do it in a very broad way. They could rule no tariffs ever under IEEPA. Well, then we'll talk about other alternatives, but that would be pretty clear. They could rule, you don't have exactly the proper match between the problem and the solution. Or, there are all kinds of ways that they could come out, and each one of those would have different implications in terms of the president's power.
네, 그 질문에 대한 답은 사실 저도 제대로 드릴 수가 없는 부분이라고 말씀을 드리고 싶습니다. 아무래도 이러한 견해에 대해서 굉장히 다양한 견해가 오고 가고 있고, 그리고 전체적으로 제가 주변 분들과 얘기를 해봤을 때, 물론 이것도 이제 랜덤으로 제가 알고 있는 분들이랑 얘기를 해봤을 때 결과이지만, 대체적으로 대법원, 연방 대법원이 여태까지 1심, 2심에서 나왔던 그 결과에 대해서 크게 반하지는 않을 것이라는 그러한 예측이 있었습니다. 근데 물론 다시 한번 얘기 드리지만 이 같은 경우는 제 주변 분들에 대한 견해이기 때문에 정확하다고는 말씀을 드릴 수가 없습니다. 또 제가 개인적으로 대법원을 매일매일 모니터링하는 그런 인원도 아니기 때문에 대법원의 경향성이나 이런 거에 대해서는 제가 얘기를 드릴 수가 없습니다. 그래서 여기에 관해서는 저희가 2가지 질문에 대해서 생각을 해볼 필요가 있는데, 첫 번째 질문 같은 경우에는 과연 연방대법원이 어떠한 결과를 낼 것인가, 어떠한 결심을 할 것인가 일 것이고, 그보다 더 중요한 2번째 질문 같은 경우에는 대법원이 어떠한 영역에서 판단을 하고 결심을 할 것인가입니다. 아까 말씀드렸다시피 1심 CIT 국제무역법원에서는 총 3가지의 견해에 대해서 3가지 방향으로 낼 수 있는 결심을 얘기를 해왔습니다. 그렇기 때문에 이것이 단순히 yes or no, 기다 아니다 이런 판단이 아니라 어떠한 영역에서 그것을 좁게 바라볼 것인지 아니면 넓게 바라볼 것인지, 대통령의 권한이 좁은 영역에서 있는 것인지 넓은 영역에서 있는 것인지, 관세는 완벽하게 안 된다라고 얘기를 할 것인지 아니면 이번 경우에만 이 정도의 정도로 관세를 부과하는 것은 안 된다라고 판단을 할 것인지가 저희가 바라볼 수 있는 키포인트라고 말씀드릴 수 있겠습니다.
Yeah, so I want to go back to your, the power balance between Congress and the president. Because you mentioned, foreign affairs, which is the realm of executive power, versus taxation, which is given for the Congress, right? So, but recent decades, as you mentioned, Congress has allowed the president to act freely on trade, right? Imposing tariff, right? So, do you think that the Congress will try to take that some of authority back to themselves? If so, what's going to happen really? And will that, like the Congress getting more power in terms of imposing tariffs and trade policy, will that make trade policy more predictable for US allies like Korea?
네, 다음 질문 한번 드려보고 싶습니다. 아까 저희가 얘기했던 그 국회, 의회와 대통령, 행정부 간의 권력 균형에 대한 문제인데, 앞서 얘기했다시피 대통령은 이제 외교 문제의 그 권한으로 어떻게 보면은 조금 더 강력한 조세 문제에 대한 권력을 이양받은 그런 경향이 있는데, 최근 몇 년간은 그래서 어떻게 보면은 미국 의회가 미국 대통령에게 이런 관세 관련 권한을 점점 더 이양하는 그런 경향성이 있었습니다. 그렇다면은 다시금 이번 문제로 인해 미국 의회가 미국 대통령에게 이런 권력을 다시 재탈환을 할 것인지, 그리고 만약에 재탈환을 한다면은 우리 동맹국의 입장에서는 이런 관세나 무역 관련 문제가 조금 더 예측 가능하게 되는지에 대한 질문을 드리고 싶습니다.
Yeah, so the relationship between Congress and the president with respect to trade has always been complicated in the United States. We have this very awkward. It used to be that go back to the middle of the last century that trade agreements were treaties and had to be approved by the Senate. And We had the International Trade Organization, the Atlanta Charter was not approved by the Senate. So we worked out this sort of really awkward relationship between the president, where the Congress would authorize trade negotiations, but with negotiated objectives, with a fast track approval process, et cetera. So it's always been this sort of tricky. The one thing you could sort of count on traditionally, well, there are two things to say. One was that you could always count on Congress to sort of fight fairly ferociously for its prerogatives. Basic principles, of separation of powers. Montesquieu, you don't want people to end, and you don't want concentrated power because you end up with tyranny, right? So you create three branches of government, you give each of them powers. Every branch of government wants to struggle for its own power, and therefore nobody ends up being a tyrant, right? I mean, that's the basic principle of all modern republics. And so you could pretty much count on Congress being pretty ferocious about fighting for its prerogatives. And yes, Congress has approved a variety of delegations of power to the president, but they're always been sort of circumscribed. And I mean, you look at EPA, it's pretty, you have to have extraordinary and unusual emergencies, I mean, and the measures taken have to deal with, exclusively with addressing that emergency and address no other purpose, So I think Congress, with these various measures, was recognizing that it is tricky for a president when he's dealing with sort of foreign affairs crises and wars and sanctions. It was Trade with the Enemy Act was the predecessor of IEPA. So if you have these sort of foreign affairs emergencies of some kind, you have to give the president some scope to take action. A lot of this stuff comes out of the First World War. I mean, you seized German ships when the U.S. declares war on Germany. So you wouldn't want to prevent the president from taking those types of actions. The question is whether they really intended to delegate as much power, and whether they really expected to have a president who, I'm going to try and say this carefully, a president who, seems willing to sort of grasp for any element of power that you arguably have in almost every sphere. I mean, he really is, his view of his powers, in almost any sphere, whether it's trade or anywhere else, are extremely expansive, right? I don't think they could have reasonably anticipated that when they wrote this legislation, but that's my personal view.
네, 어떻게 보면은 최근 몇 년간 그리고 저번 이제 세기부터 이러한 권력의 문제는 계속해서 나왔던 것 같습니다. 그래서 미국 상원이 어떻게 보면은 이런 무역 문제에 대해서 최종 권한을 가지고 있고, 무역 협정이 일어났을 때 최종적으로 의결을 하는 권한을 가지고 있지만, 이런 점점점 이러한 권한이 대통령에게 이양되는 그런 경향성이 만들어졌고, 그렇기 때문에 이렇게 대통령과 행정부와 입법부 간의 그런 관계는 굉장히 복잡 미묘한 관계라고 볼 수가 있습니다. 특히 저희가 원칙적으로 바라봤을 때는 각 부처 간 그리고 행정부, 사법부, 입법부 간의 견제와 균형의 문제가 있기 때문에 원칙적으로는 이러한 세 부처가 각각의 권력을 견제를 하고 본인들이 가장 맞는 권력을 더 갖기 위해서 노력을 하는, 그래서 자연스럽게 서로 견제가 되고 균형이 맞아 떨어지는 그런 다이나믹이 펼쳐졌지만, 최근 관세 문제에 관해서는 이러한 경향성이 점점점 옅어지는 것이 현실입니다. 그리고 이러한 관세 권한 이양에 관해서는 물론 의회가 대통령에게 권한 이양되는 경향성이 있었지만, 그 문구에는 항상 제한적이라는 단서가 있었습니다. 지금 굉장히 주목이 되고 있는 국제비상경제권한법 IPA 같은 경우에도 항상 단서를 달았던 것이, 이것이 위급 상황일 시에, 국가의 안보에 위협이 되는 위급 상황일 시에 대통령에게 이러한 권한을 이양을 한다라는 부분이 있었던 문제이고, 그렇기 때문에 이것이 굉장히 복잡 미묘한 문제라고 할 수 있습니다. 사실 역사적으로 봤을 때 세계 1차 대전, 세계 2차 대전은 미국이 국가 안보의 위협을 당할 시에는 확실히 대통령이 다양한 방법을 통해서 그런 국가 안보 위협을 헤쳐나갈 수 있는 그런 권한이 이양이 되어야 되는 것이 사실입니다. 하지만 이것이 어느 정도로 이양이 될지, 물론 제가 판단하기에도 대통령이 완벽하게 이것을 할 수 없다, 이런 권한을 가질 수 없다라고 금지하는 것은 원칙적으로 그런 판결은 나오지 않을 것이라고 예상이 됩니다. 다만 어느 정도의 이양이 과연 맞을지에 대한 그런 원안의 문제가 다시금 생각해볼 문제인 것 같습니다.
Yeah, so going back to your first, the answer to the first question, you talked about a little bit about different measures, like different statutes that President Trump can use, right, other than this IEPA. So what are those? Like we hear 301, 232, 201, right? Are those going to be the primary tools if IEPA is struck down, or is there any other tool that the administration can rely on?
Yeah, okay. Let me go back to the question about Congress. There's one more thing I realized which is very important, which I did not say. So I said traditionally Congress has always been very jealous of its powers and defended them against presidents. That's not the current state of affairs. I mean, the degree of, I would say, sort of party alignment in the current system is different. Republicans, who are the majority in both houses, are very reluctant to challenge the president on anything, basically. So, in the past, you would see Republicans and Democrats standing up and agreeing. They couldn't agree on anything else, but they could agree that this is congressional power. And that you're not hearing right now. So even if, so a reassertion of, the ability, just to say that, under those circumstances, it may not be that greater congressional power over trade would actually have much impact. But okay, let's come to the alternatives. Oh, sorry, go ahead.
네, 그래서 앞서 질문에 대해서 언급할 때 제가 까먹은 부분이 있는데 한 가지 얘기를 드리고 싶은 부분이 제가 앞서 얘기할 때는 의회가 대통령과의 그 권력 균형 문제에 있어서는 계속해서 본인들의 권한을 찾으려고 하는, 견제하려고 하는 그런 움직임이 있었다고 얘기를 드렸는데 그것은 역사적으로 그랬다는 것이고 지금 같은 경우에는 그런 경향성이 전혀 보이지 않고 있습니다. 어떻게 보면은 정당 내부의 구조적인 문제 때문이라고 볼 수도 있는데 최근 들어서는 공화당 의원들, 사실 공화당이 하원, 상원 모두 양원에서 다수당을 차지하고 있음에도 불구하고 공화당 의원들이 대통령의 결정에 대해서 반대하는 부분에 대해서 굉장히 소극적으로 임하고 있습니다. 그래서 예전 같은 경우에는 이것이 의회 권한이다라고 당당하게 말하는 그런 의원들이 많았던 반면에 이런 경향성이 점점 사라지고 있습니다. 그리고 다음 질문으로 넘어가서 저희가 아까 얘기를 했을 때 이제 IPA 말고도 대통령 행정부에서 이런 관세 부분에 대해서 다시금 주장을 할 수 있는 그런 정당성을 부여하는 법에 대해서 얘기를 했습니다. 그래서 311조도 있고 312조도 있고 다양한 그런 IEPA 말고도 다양한 법안이 분명히 존재를 하는데 그러면 이 IEPA에 대해서 대법원이 대통령이 권한을 발휘할 수 없다라는 결심을 내릴 경우에는 행정부가 이러한 다른 311조나 312조의 법안에 관련해가지고 다시금 주장을 제시를 할지 어떤 법안이 있는지에 대한 질문이었습니다.
Okay. So going back to this alternatives, of course, you have traditional trade remedies, anti-dumping, countervailing measures, safeguards. We need to conduct investigations. At least, elements of those require decisions by an independent agency, the International Trade Commission. They tend to be very product specific. Two of them are country specific. So those are quite narrow. Those are tools the U.S. has been using for decades, and most countries use, but they're not going to replace IEPA. You have Section 301. Section 301 is really focused on identifying situations where foreign countries are either not respecting their commitments under trade agreements or where they're engaged in some other discriminatory behavior that unreasonably burdens trade. So there's supposed to be tools about unfair trade. The president has used them quite broadly, obviously, with respect to China. There's the one on shipbuilding. So you can see that they can be significant, but they still have a requirement for an investigation to identify these unfair behaviors and respond to unfair behaviors in some way. So not really a replacement for IEPA either. You have Section 122 of the Trade Act. That's a piece of legislation specifically about balance of payments problems. That's the one the Court of International Trade relied upon. But that's the limit. There are really serious limits on how long you can impose the measures for and what level the measures are. So it is also really not a replacement at all. That sort of codifies President Nixon's behavior in the early 70s when we went off the gold standard. So that really leaves, so Section 301 is probably the most viable of those, and that leaves Section 232. Section 232, so you're talking about national security, you're talking about measures taken with respect to articles. It talks about articles, so it's, Section 232 is not about imports generically, about imports of articles, so sectors and things like that. But it's rooted in national security, so the president has a lot of deference. There is an investigation process. The investigation process is done within the Department of Commerce, not in an independent agency. So in fact, Secretary of Commerce tells, don't want to be too cynical, but you're not an independent agency, you're not going to do something probably that if the president wants a positive outcome, you're likely to get one. And what we've seen, of course, is that these 232s have gone crazy. From almost never being used. For decades, no one even knew in the United States what Section 232 was. Now there are a dozen different 232 investigations. They cover, not just steel and aluminum, but automobiles. I have a list of them here: copper, timber, pharma, semiconductors, trucks, critical minerals, aircraft, robotics, personal protective equipment. The list is huge. And in fact, if you think about how 232s have been working, I think there are two things that are happening. One is they're the lever that makes people say, oh, give me some reciprocal tariffs, please. Because who knows what's going to happen with the 232. So if you're Korean, 30% or whatever it is of your exports to the United States for automobiles, just give me a nice safe 50%, thank you. Goodness only knows what's going to happen with the 232. So that's one sort of phenomenon there. And the other thing I think is that the president is clearly laying the groundwork. If you have this many 232s going through, at the end of the day, if the IEEPA tariffs go away, so what? You can pretty much cover. But right now, what we have is sort of reciprocal tariffs. They're inclusion and less excluded, right? So IEEPA tariffs could be, not covered unless subject to. 232 tariffs is not covered unless subject to, but if you cover enough sectors, you can achieve exactly the same result as you can with IEEPA. So cynically, all this whole pipeline of 232 cases going forward now, by the time those are all in place, you may be really desperate to maintain your reciprocal tariffs.
네, 그래서 여러 가지 조항에 대해서 얘기를 해주시는데, 일단은 가장 기본적으로 저희가 전통적으로 해왔던 반덤핑 관련 무역 규제들이 있겠습니다. 이거 같은 경우에는 이제 조사 당국에 조사를 의뢰를 해서 독립적으로 이루어진 조사 당국에 의뢰를 해서 그리고 또 국제 패널에 맡길 수도 있겠고요. 그래서 다양한 방법을 통해서 분쟁을 해결하는 그런 방식이 있습니다. 과거에 미국도 했고 다른 나라도 해왔지만 이 조사가 이루어지는 과정이 현재는 잘 이루어지지 않는 것이 현실입니다. 그렇기 때문에 한계가 분명히 존재를 합니다. 두 번째로 301조 불공정 무역 관세 같은 경우에는 외국과의 무역 관계에 있어서 그 외국이 불공정하게 미국 기업에 대해서 불공정한 조치를 취한다고 생각이 되면은 이제 미국이 그 반대로 관세를 취하는 그런 조항이라고 할 수 있습니다. 그래서 최근에 트럼프 대통령이 중국에 대해서도 그리고 조선업에 대해서도 다양한 방면으로 이러한 조항을 활용을 해왔습니다. 하지만 이런 조항 같은 경우에는 조사를 필요로 한다는 그런 단점이 있습니다. 조사 단계가 무조건적으로 필요를 하기 때문에 어떻게 보면 IEPA의 완벽한 대체제가 될 수는 없다는 것이 제 견해입니다. 그리고 201조 같은 경우에도 세이프가드 관제를 통해서 이제 닉슨 시대에 많이 사용이 됐었는데 이거 같은 경우에도 그 조사 단계가 필요를 하기 때문에 완벽한 대체가 될 수 없습니다. 또 한 가지 저희가 주목해야 할 부분이 232조 국가안보 관세 부분입니다. 이거 같은 경우에는 이 조항 같은 경우에는 과거에는 이 조항에 대해서 알고 있는 사람이 거의 없었습니다. 최근 20년간은 이 조항에 대해서 아는 사람이 거의 없었던 반면에 근래 들어서 압도적으로 많이 232조가 대두가 되고 행정부에서 활용을 하면서 많은 부분들이 관심을 가지게 됐습니다. 그래서 다양한 섹터나 인더스트리 산업에 많이 사용이 되는데 자동차를 포함해서 비행기, 로보틱스 등 다양한 부분에서 국가 안보에 연관이 되어 있다는 산업이라고 판단이 되기 때문에 232조가 활용이 되었습니다. 그래서 최근 들어서는 동맹국을 포함한 미국의 무역 교역국들이 그냥 232조 말고 그냥 보편적인 관세로만 해결을 하면 안 되겠나 하는 그런 견해도 가지고 있습니다. 이 232조를 통해서 미국 행정부가 계속해서 더 강한 그런 관세를 부과를 하기 때문에 차라리 그냥 15%의 보편 관세가 더 낫지를 않나 할 정도로 이렇게 232조 국가안보 관세가 다양한 방식에서 강력하게 활용이 되고 있습니다. 이 232조 같은 경우에는 구조적으로 하나의 산업, 하나의 부품에 대해서만 부과가 되는 관세이기 때문에 보편적으로 활용이 되는 IEPA에 비해서는 보편적이지 못한다는 그런 단점이 있습니다. 다만 최근에 트럼프 행정부가 진행하고 있는 것처럼 다양한 산업, 다양한 부분에 계속해서 232조 국가안보 관세를 부과를 한다면은 이러한 부분에 대한 단점이 사라지고 IEPA의 대체가 될 수도 있다는 부분은 역시 존재합니다.
I think it's really interesting that you mentioned 232 can eventually kind of replace IEPA, or even like partners might be like, oh, we just want to with this purple tariff instead of the sectoral tariff. But we don't have much time left, so I'm going to just jump to my final question. So looking ahead as these court challenges unfold, like what kind of legal development should we as Koreans focus and watch closely?
네, 그래서 232조가 결과적으로는 IEPA를 대체할 수도 있다는 점, 그리고 최근에 동맹국들이나 교역국들이 차라리 보편 관세를 부과를 바란다는 점 굉장히 인상 깊게 알아봤습니다. 그렇기 때문에 어떻게 보면 저희가 지금 시간이 부족하기 때문에 제가 최종적으로 준비한 마지막 질문으로 넘어가도록 하겠습니다. 최근에 미국이 법원 내 판결, 그 연방 대법원의 판결이 이어지면서 과연 우리 한국인의 입장에서는 앞으로 어떠한 그런 법적인 측면에서 준비해야 될 부분이 있을지, 법적인 판결을 준비해야 될 부분이 있을지에 대한 것이 저의 최종 질문.
Yeah, this may not be the answer you're looking for. I mean, I think from what I just said in response to the last question, I mean, a victory, in the Supreme Court is not going to mean that all of a sudden the United States sort of returns to its, sort of 20 years ago or even 4 years ago sort of open economy. There's a lot of space and there are a lot of different tools for a president who is really committed to sort of changing our trading relationship with the world to do things. So, and there's already been a lot of litigation about 232, and we've seen that there's a lot of space there because it's about national security. And we've already seen 232, of course, basically, the national security rulings in the WTO, it would never allow these types of measures, but the U.S. has, sort of disconnected itself from that concern. So I hate to say it, but maybe Korea needs to sort of pragmatically try and figure out what kind of arrangement we can negotiate, because it can't count, I think, on the courts to somehow sort of, roll things back to what you're used to. I don't think that's going to happen during this administration.
네, 어떻게 보면 여러분들이 원하시는 답변이 있을 텐데 제가 그 답변을 드리지는 못할 것 같습니다. 그러면 대법원에서 그 기존에 있었던 판결이 유지가 되고 1심, 2심에 있었던 판결이 유지가 되면서 최종적으로 승리를 하더라도 이것이 미국이 지난 저번 20년 전 혹은 최소한 4년 전에 이루어졌던 것처럼 다시금 국제 경제에 합류를 해서 보호무역 조치를 해제한다는 말은 절대 안 될 것이기 때문입니다. 예를 들어서 232조 같은 경우에도 국가 안보와 계속해서 연결이 되기 때문에 행정부로 하여금 조치를 취할 수 있는 부분이 굉장히 많이 존재를 합니다. 그렇기 때문에 꼭 이 판결이 성공을 하더라도 그 전으로 돌아간다는 말은 못할 것 같습니다. 그리고 또 이번 232조 판결 같은 경우에도 WTO는 계속해서 이러한 부분에 대해서 반대를 하는 바이지만, 그리고 허가를 하지 않는 바이지만, 미국 같은 경우에는 최소한 그런 부분에 있어서는 국제사회의 얘기를 이제 조금 더 멀리 떨어지고 본인들을 이격시키고 계속해서 이러한 조치를 취하는 부분이 굉장히 존재를 합니다. 그렇기 때문에 한국 입장에서는 이런 부분들을 감안을 하고 대법원의 판결이 나온다고 하더라도 그 이후에 실용적으로 협상을 어떻게 진행할 수 있을지에 대해서 생각하는 것이 굉장히 좋을 것 같습니다. 다시 한번 얘기를 드리자면은 법원의 판결과 무관하게 미국이 20년 전에 있었던 미국처럼 국제무역에 그런 양상으로 참가를 하는 것은 최소한 지금 행정부가 있을 때는 쉽지 않을 것이라고 생각이 듭니다.
Thank you. Now we're open for questions to the audience. So we'd love to hear from you now. So if you have a question, please say your name and affiliation. And since we have the translator, so if you make your question as concise as possible, that will be helpful.
Jim Wayman, an overly broad and simplified generalization of litigation administration would be that the president is tended to lose a trial at appellate court level, and then in cases get to the Supreme Court, they are any injunctions and such are lifted, and the cases are kicked back, typically on narrow procedural grounds, recognizing the exceptions. Now, a political scientist would say that is classic institutional behavior to protect your institution and avoid a confrontation with the executive. So my question is, are there readily apparent procedural grounds upon which the court could avoid ruling on the merits in this case?
Not that I'm aware of it, actually. I think not. I think the court was pretty anxious. I mean, they could have said no, and let the Court of Appeals for the Federal Circuit ruling stand. No, I think they're gonna rule on this. I'm not litigating the case, so maybe I'm missing something, but I can't think of any sort of procedural grounds. They might rule on narrow grounds, or they might rule on broad grounds, but I don't think they're going to rule on procedural grounds. That's I'd be surprised.
네, 질문 먼저 드리겠습니다. 어떻게 보면 굉장히 일반화할 수도 있겠지만 정치과학적으로 봤을 때 행정부와 어떻게 보면 직접적으로 접촉을 하는 그런 면이 있기 때문에 법원이 판결을 내릴 때 절차적인 부분에서만 판결을 내리지 않을까 하는 그런 견해도 존재를 하는데 어떻게 생각을 하시는지에 대한 질문이었고 답변 같은 경우에는 그러지 않을 것이라고 생각을 한다고 밝혔습니다. 왜냐하면 기존의 1심, 2심 법원 역시 이 부분에 대해서는 안 된다라고 확실하게 의사를 표현을 하였고 그리고 과연 그 대법원도 역시 판결을 할 때 이것이 좁은 부분에서의 법문 해석을 할 것인지 아니면 넓은 부분에서의 법문 해석을 할 것인지에 대한 문제이지 이것이 절차적으로만 판단을 해서 결론을 내리지는 않을 것이라는 그런 답변이었습니다.
Any other questions? Sure. Yeah, go ahead.
준비돼서 최우석 부탁드립니다. 지금 만약 지금 트럼프한테 구하는 거가 대법원에서 만약 위법하다라고 판결이 된다면 그중에 다른 고발을 원에 올려가지고 첫 번째 이제 관세 구할 수 있을 것이라고 얘기했는데 그 약간 실무적으로 먼저 말씀하신 것처럼 다른 고발을 원에 있을 때는 독립기구에서 조사를 한다든지 해서 시간이 어느 정도 필요할 것 같은데 지금 아시기로는 미국 정부에서 그런 준비가 이미 되고 있는 건지 혹은 판결이 난 다음에 하는데 그런 절차적인 시간이 더 필요하기 때문에 실질적으로 관세가 일정 기간 동안 부과가 안 되는 그런 시간이 발생하게 되는 거죠. 그런 게 하나 궁금하고 또 하나는 약간 좀 큰 질문인데 이제 무역 전문가시니까 지금 트럼프 정부에서 하고 있는 이런 관세 정책들이 기존에 있는 WTO나 무역기구들이 기존에 하고 있는 그런 관행들이나 그런 체제를 많이 이제 바꾸고 있는데요. 현재 WTO나 이런 기구들에 미치고 있는 영향과 그거에 대한 이제 의견을 한번 보셨습니다.
My name is Chen, so the attache of transportation department within the South Korean embassy in the United States. So I have two questions for today. The first question would be, since you mentioned that in the case of the Supreme Court struck down the tariff policies of administration, then there's going to be other statute that they're going to be using. So I'd like to ask in this regard in the working level. So I'm assuming that there will be a time needed for administration to use this statute since it needs investigation by the independent counsel. So in a working level, I would like to ask if the US government is preparing for this other methods replacement of IPA, and also if so, if the Supreme Court strikes down the tariffs, and then there's going to be a time that the tariff is postponed and tariff is not imposed to the US partner countries. That is my first question. And the second question is a bit broader question.
Could I take the first one first, because I'm going to forget it otherwise. I think that was already two questions, in fact, so maybe you're moving on to the third. So so these different types of measures involve different investigation procedures. Some of them don't require any investigation at all, right? The 232s do require an investigation. It is, traditionally there's going to be a big fat report prepared, and then eventually it goes to the president with recommendations, et cetera. Section 301 has traditionally worked the same way. As I pointed out, there are so many 232s in the pipeline now. Some of them in place, many of them underway. They might be able to sort of rush those out fairly quickly. There are maximum timelines, but I don't know that there are minimums necessarily. And since the extent of the discretion that the president seems to have with respect to the substantive findings is really very substantial, it maybe could do it pretty quickly. But I think seeing that whole pipeline of 232s, I think you have to understand those. The way I understand those 232s is they are, on the one hand, a background to facilitate negotiations with respect to reciprocal tariffs, and on the other hand, a backstop that it will be, could be potentially to a substantial degree in place, or not take very long to put in place.
먼저 첫 번째 질문에 대한 답변 먼저 드리도록 하겠습니다. 얘기해 주셨듯이 여러 가지 조항 같은 경우에는 사실 독립적인 조사가 필요한 그런 조항이 많습니다. 다만 232조 같은 경우에 또 역시 그런 조사 단계가 필요하지만 다만 저희가 주목해야 될 부분은 이미 232조는 행정부에 의해서 많이 다뤄졌고 그렇기 때문에 다양한 섹터에 대해서 이미 조사가 혹은 그런 과정들이 준비가 되고 있는 부분이 분명히 존재한다는 것입니다. 여러 가지 파이프라인을 통해서 이 232조에 대한 준비가 진행이 되고 있기 때문에 미국 행정부가 만약에 원한다면은 이러한 준비 기간 자체는 그렇게 길지 않을 것이라고 생각됩니다. 232조 같은 경우가 저희가 모두 다 알다시피 원래는 상호 관세 협상에 대한 그런 부분을 더 서포트하고자 준비가 되었지만 두 번째 방편으로 만약에 IEPA가 해당이 되지 않는다면 이에 대한 대체 방안으로도 충분히 활용이 될 여지가 있다는 것입니다.
And if I could just sort of supplement that with one more thing, steel and autos are already in place, right? What portion of Korea's exports to the United States are steel and autos? Pretty substantial.
그리고 또 한 가지 주목해야 될 부분이 어떻게 보면 철강이랑 자동차에 대한 그런 품목 관세 같은 경우에는 이미 진행이 되고 있기 때문에 그 부분 역시 오히려 그 미국 행정부의 입장에서는 더 준비하기 편하게 작업할 수 있겠습니다. And then the second question will be about it's a more broader question. So for the Trump administration, there's a tendency that they ignore the rulings or the rules of the WTO. So my question would be, as of now, for the current status quo, how is WTO responding to this tendency, and what are they preparing? What kind of rules they are trying to take in this thing?
Okay, I guess the first thing I'd say is, the WHO as an organization, as an institution, as a secretariat, for example, is not really an independent act. The question really is how the rest of the world is responding in the WTO context to U.S. behavior. And the sort of challenges on the one hand, you sort of, there is an idea out there that that the rest of the world should, stick with multilateralism, continue to apply the existing rules, just sort of, leave the Americans out of it if the Americans don't want to play by the rules, but we'll maintain it for the rest, and most of the world's trade is still regulated, et cetera, et cetera. The difficulty here, of course, is that, the US is also asking other countries to provide treatment to the United States that would also be WTO inconsistent. So that's one danger with that approach, is that, this may, if you have a major player, disregarding the rules on a systematic basis and sort of demanding that other players do as well, so the US is asking for preferential treatment in many cases, and at the same time, it is asking other countries to take actions against the WTO member, China. So, how is the WTO going to sort of survive through that? I don't mean to say it's going to go away or something, but it's not a sort of very encouraging prospect. So how is the WTO going to respond as an institution? They're only going to be able to do what other members are prepared to, get together and do.
그래서 한 가지 먼저 얘기를 해야 될 부분이 WTO는 어떻게 보면 하나의 제도라는 부분입니다. 하나의 행위자가 아니라 그 제도를 어떻게 지탱을 시킬지에 대한 그런 역할을 하는 부분인데, 그래서 제도라고 보는 부분이 더 맞겠고, 그렇기 때문에 WTO에게 중요한 것은 미국을 제외한 다른 국제사회 일원들이 이 미국의 행위에 대해서 어떻게 바라보는지와 관련된 것이기 때문에 관련된 것일 것입니다. 그런 방면에서 WTO에게 가장 어떻게 보면은 어려운 점이라고 할 수 있는 부분이, 미국이 단순하게 WTO를 무시하는 것뿐만 아니라 WTO에서 WTO에서 진행하는 그런 규제안들에 대해서 다른 국가들에게 이러한 규제안들에 반대되는 그런 행위를 하도록 강요하는 부분도 충분히 있다는 부분입니다. 그래서 미국 같은 경우에는 예를 들어서 다양한 국가들에게 최혜국 대우를 바라는 부분도 분명히 존재를 하고, 그리고 또 중국에 견제를 하는 그런 부분을 다른 국가들에게 바라고 있는데, 어떤 문제 같은 경우에는 WTO에서 진행하는 그런 제도와는 반하는 그런 부분이 될 수 있겠습니다. 그렇기 때문에 WTO라는 제도가 진행되는 데 있어서는 그렇게 긍정적인 전망이 아니라는 부분을 얘기를 드리고 싶습니다.
Time's up now.
Thank you, Jesse, for sharing your insights today, and I think it was really helpful to understand, what to look out for, what this case is about, and how it's going to lead to Korean policymakers and businesses. So thank you so much, and thank you so much for attending the conversation today, in person and online, and we look forward to continuing this conversation in our future high-tech events. So thank you.